VTL Section 1192.6, Commercial Motor Vehicles, per se, Level 2. Facing a charge under New York Vehicle and Traffic Law, VTL, Section 1192.6 can upend a commercial driver's life. Charges are overwhelming for those who depend on their commercial driver's license to earn a living because penalties include fines, license suspensions, and long-term consequences. Protecting your rights and future requires a tailored defense, and the Kugel Law Firm emphasizes that working with a skilled New York DWI lawyer can make a significant difference in the outcome. Under VTL Section 1192.6, prosecutors must prove two elements. The accused was operating a vehicle classified as a commercial motor vehicle, and their blood alcohol content, BAC, was more than 0.06% but less than 0.08%. This provision is stricter than the rule for non-commercial drivers, for whom driving with a BAC of 0.08% or more constitutes a per se violation. These lower limits reflect New York's heightened concern about the risks posed by intoxicated drivers of large trucks and buses. A conviction under VTL Section 1192.6 is a misdemeanor, so an attorney must navigate both criminal law and regulatory issues. Because commercial drivers often carry hazardous loads and transport passengers, the legislature has imposed tougher standards to promote public safety. The statute interacts with Section 1192.5, which covers lesser BAC readings for commercial drivers. Section 1192.5, sometimes called Level 1, applies to BAC readings between 0.04% and 0.06%. It is classified as a traffic infraction with fines of $300 to $500 and up to 15 days in jail. Section 1192.6, labeled Level 2, addresses BAC readings above 0.06% but under 0.08%. It elevates the offense to a misdemeanor with harsher consequences. Both sections trigger at least a 1-year revocation of a commercial driver's license, but a Level 2 conviction carries more stigma, potentially affecting future employment and professional licensing. These distinctions underscore why a knowledgeable attorney's guidance is essential when a driver is charged. Penalties for violating Section 1192.6 are significant. A first-time conviction subjects a driver to fines ranging from $500 to $1,500, a jail term of up to 180 days, and a mandatory revocation of the commercial driver's license for at least 1 year. If the offense occurs while operating a vehicle placarded for hazardous materials, the revocation period is at least 3 years. Beyond these formal punishments, convictions lead to long-term consequences. Many transportation employers maintain strict hiring policies regarding driving while intoxicated offenses. Insurance premiums may rise or coverage may be denied, and the conviction remains on the driver's permanent record, affecting future legal proceedings and job prospects. Because such consequences threaten a driver's livelihood, early consultation with a lawyer can help mitigate harm. The severity of penalties increases with prior offenses or aggravating circumstances. A second conviction within 5 years leads to fines between $1,000 and $5,000, imprisonment of up to 4 years, and a lifetime revocation of the commercial driver's license, subject to limited exceptions. Operating a vehicle placarded for hazardous materials is considered an aggravating factor and results in a mandatory minimum 3-year license revocation even for a first offense. These escalating sanctions illustrate the stakes when facing repeat charges and highlight why drivers benefit from representation by an experienced attorney. At a roadside checkpoint, a breath test recorded a BAC of 0.07%, which is below the 0.08% limit for non-commercial drivers but above the 0.06% threshold for commercial drivers. First, counsel can challenge the accuracy of the BAC test, arguing that breathalyzers and other chemical testing devices must be properly calibrated and maintained. Improper calibration, incorrect administration of tests, or certain physiological conditions can produce unreliable results. Second, the defense may question the legality of the traffic stop. Law enforcement must have probable cause or reasonable suspicion to stop a vehicle. If the initial stop lacked a valid legal basis, any evidence obtained, including BAC test results, may be inadmissible. Successfully contesting the stop can significantly weaken the prosecution's case. Developing these defenses requires a thorough understanding of New York's DWI laws and close collaboration between the driver and an attorney. Section 1192.6 expressly prohibits operating a commercial motor vehicle while having more than 0.06% but less than 0.08% of alcohol in the blood, as shown by chemical analysis, and it allows prosecutors to pursue charges under other subdivisions when applicable. Being charged under this law can profoundly affect a driver's career, finances, and future. The Kugel Law Firm stands ready to help protect your livelihood, defend your rights, and pursue strategies aimed at achieving the best possible outcome. To discuss your case, you can contact the Kugel Law Firm at 212-372-7218 or visit them at 111 E 125th Street, 2nd FL, New York, New York, 10035. A consultation with a lawyer or attorney from this law firm can be the first step toward safeguarding your career under New York's commercial motor vehicle laws.